In today's session, discussion will be on the right to equality as enumerated in Part 3 of the Indian Constitution by Articles 14 to 18. We must remember that equality is the basis of all other rights of the individual, and it is the foundation stone of the edifice of democracy. In its struggle for social and political freedom, mankind has always tried to move towards the ideal of equality for all. The urge for equality and to move towards ideal of equality has been the motive force of many revolutions, like Glorious Revolution 1688, French Revolution 1789, even the October Revolution of Soviet Union held in 1917. The Charter of the United Nations reaffirms its faith in the equal rights of men and women. Indeed, real and effective democracy cannot be achieved unless equality in all spheres is realized in a full measure. However, complete equality among men and women in all spheres of life is an ideal. This goal is to be attained only by the march of humanity along the long and difficult path of economic, social, and political progress. And so far as the thoughts and ideas generated by capitalist and socialist world is concerned, we can find that so far as the capitalist world is concerned, liberal democratic nations, they nurture social and political equality, whereas socialist world gives stress on economic equality. They feel that economic equality is the basis of all other equality. However, socialist world has become an insignificant entity, so we shall focus on liberal ideas of right to equality, which was the basis of inclusion of right to equality in Indian Constitution also. The Constitution and the laws of the country can therefore at best assure to its citizens only a limited measure of equality. Therefore, political and legal equality have been given the status of fundamental right in the Indian Constitution, and enumerations of these rights are visible in Part 3, that is the justiciable part of Indian Constitution, and other rights, social and economic rights, are being left within the scope of directive principles of state policy as enumerated in Part 4 of the Constitution. Realization of economic and social equality depends on country's socio-economic development. The right to equality guarantees protection not only against discriminatory laws passed by the legislatures, but also prevents arbitrary discretion being vested in the executive arm of the government. As we know that in modern times, executive is armed with vast powers. Even though there is a term called delegated legislation. By using the power to enact laws on the skeleton derived by the parliament, executive even enjoys wider power than the parliament, even in parliamentary democracies. And if that particular parliamentary democracy is being constituted by the majority party, then cabinet, that is the executive arm, often exercises discretionary and arbitrary power. So, this enumeration of fundamental rights curtails the arbitrary power of the executive as well as those of the legislative arm of the government. Keeping this vision in mind, the framers of the Indian Constitution incorporated the right to equality in Article 14 to 18 of Part 3 of the Constitution. Article 14 of the Constitution. Article 14 of the Constitution is titled as Equality Before Law. What it declares? It declares that the state shall not deny to any person equality before law or equal protection of the laws within the territory of India. The phrase equality before the law finds a place in almost all the written constitution that guarantee fundamental rights. Equality before the law is an expression of English common law. However, England does not have a written constitution. In England, this essence of equality lies in the rule of law. I shall come to that at the end of the session. While equal protection of law, however, owes its origin to American Constitution. Both these expressions have been used in the Universal Declaration of Human Rights. What is the implication of equality before law? The concept of equality does not mean absolute equality. I have already said that absolute equality physically is not possible to achieve. It implies absence of any special privilege by reason of birth, creed, race, religion, language, sex, etc. It also suggests that equal subjection of all individuals and classes to the ordinary law of the land. Guarantee of equality before the law means that no person is above law and every person, irrespective of his position or status, is under the authority of law and subjected to the jurisdiction of ordinary courts. Thus, every official, from the Prime Minister down to a constable or a collector of taxes, is equally responsible for lawful action or inaction in his or her authority. That is, he or she cannot do anything which is not permitted or sanctioned by the law of the land. The rule of law embodied in Article 14 is thus the basic feature of the Indian Constitution, and it is the foundation stone of all the other rights of the people. It cannot be destroyed. This particular right cannot be destroyed even by an amendment of the Constitution under Article 368. This basic feature, this connotation, specifically this term, basic feature, was derived by the Supreme Court in Keshavananda Bharti case. And right to equality belong to this category, which in no way can be destroyed by the arbitrary action of the government. Equal protection of the law. It means that all persons have right to equal treatment in similar circumstances. Equal protection thus ensures equal treatment in equal circumstances and different treatment under different situations. The phrase equal protection of the laws denotes that this equal protection of laws is available to citizens and non-citizens of India. It includes, even in its coverage, any company or association or body of individuals. The equality before a law is guaranteed to all without any arbitrary discretion on any ground whatsoever. The preamble of the Constitution of India declares that there shall be an equality of status and opportunity. This right to equality is a constitutional endorsement of this pious declaration. While equality before the law is somewhat a negative concept, implying the absence of any special privilege in favor of any individual, or the equal subjection of all classes to ordinary law of the land, equal protection of law is a positive concept employing equality of treatment under equal circumstances. There are certain exceptions to this particular right. The above rule of equality is, however, not an absolute rule, and there are number of exceptions to it. For instance, foreign diplomats are immune from jurisdiction of courts. Article 361 of the Indian Constitution affords immunity to the President and the state governors. Thus, Article 361 of the Indian Constitution says that nothing in this article shall prevent the state from making any special provision for women and children. Thus, Article 361 of the Constitution stipulates three major exceptions. 1. The President of India or the Governor of a state is not answerable to any court for his official actions. 2. The President or the Governor is not subject to criminal prosecution during his term of office. And third, civil suits claiming relief for personal actions cannot be brought against the President or the Governor when they are in office. Real democracy can be achieved only by a proper balance between the equality of individual and the restrictions imposed on him in the interest of the community. Article 14 permits classification but prohibits class legislation. What does it mean? It means that the equal protection of laws guaranteed by Article 14 does not imply that all laws must be general in character. The varying needs of different classes of persons often require separate treatment and different laws in different spheres. In fact, identical treatment in unequal circumstances would amount to inequality. Therefore, to understand this, we shall have to move to Article 15. Article 15 is titled as Prohibition of Discrimination on Grounds of Religion, Race, Caste, Sex, or Place of Birth. Article 15 Clause 1 says that the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. Article 15(2) says that no citizen shall on grounds only of religion, race, caste, sex, place of birth, or any of them be subject to any disability, liability, restriction, or condition with regard to access to shops, public restaurants, hotels, places of public entertainment, etc. Or he can never be denied to the use of wells, tanks, bathing ghats, roads, places of public resort maintained wholly or partly out of state funds or dedicated to the use of general public. These discriminations are strictly punishable by law. Article 15 Clause 3 says that nothing in this article shall prevent the state from making any special provision for women and children. This is a major exception to this article. Article 15(4) says that state can make any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and the scheduled tribes. Article 15 clause 5. What does it say? It says that state can make special provisions related to the admission of scheduled caste and the scheduled tribes or for socially and educationally backward classes in the educational institutions, including private educational institutions, whether aided or unaided by the state, other than the minority educational institutions referred to in clause 1 of Article 30. The guarantee under Article 15 is available to citizens only, not to every person, whether citizen or non-citizen, as under Article 14. According to the Citizenship Amendment Bill 2003, the right shall not be conferred to overseas citizens of India. You can better see the Indian Nationality Law 2003. Article 16. It is titled as Equality of Opportunity in Matters of Public Employment. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. No citizen shall, on grounds only of religion, race, caste, sex, descent, place of birth, residence, or any one of them, be ineligible for or discriminated against in respect of any employment or office under the state. Now, nothing in this article shall prevent Parliament from making any law prescribing in regard to a class or classes of employment or appointment to an office. There are 5 exceptions. The Parliament may lay down residential qualification for some appointments in states. Article 16(3) says, Parliament can make any law prescribing that residence within a state or a union territory will be a primary requirement for employment or appointment to an office under the Government of India, under any local or any other authority within the state or union territory. 2. The state may reserve some appointments for backward classes if they are not adequately represented. Article 16 clause 4. What does it say? It says that state can make any provision for the reservation of appointments or posts in favor of any backward class of citizens which in the opinion of the state is not adequately represented in the services under the state. 3. The state may reserve some appointments in favor of scheduled castes and scheduled tribes if they are not adequately represented in the state services. Article 16 clause 4a says, state can make any provision for reservation in matters of promotion with consequential seniority in favor of the scheduled castes and scheduled tribes which, in the opinion of the state, are not adequately represented in the services under the state. The state may consider any unfilled vacancy, reserved vacancy of a year to be filled up in any succeeding year or years, which shall not be considered together with the vacancies of the year and shall not be considered together with the vacancies of any subsequent year. As we know, there are vacancies lying in many of the organizations, especially where appointments are made on the basis of a higher eligibility criteria, that is, on the higher merit basis. And what the organization can do? For subsequent years, 2 or 3 or 4 years, if it does not get scheduled castes or scheduled tribes people to be adequately to represent or to replace the same, to fill up the vacancy, then it can move for de-reservation. Then de-reservation can be done by order of the government, but with replacing that particular post in the next roster point. Again, securing another post for this scheduled caste and scheduled tribe people. Thus, state secures the interest of this scheduled caste and scheduled tribe people, and this does not imply that it is violation of equality of opportunity. Article 16 guarantees equality of opportunity in matters of appointment in state services. It does not, however, prevent the state from prescribing the necessary qualification and taking selective tests for recruitment for government services. The qualifications prescribed may be the basis of appointment. Other things which may be taken under consideration are mental excellence, physical fitness, sense of discipline, moral integrity, loyalty to the state, etc. Where appointment requires technical knowledge, technical qualification may be prescribed. The character and antecedents of the candidates may be taken into consideration for appointment in government services. Thus, parochialism and nepotism were intended to be eliminated in matters of appointment in government services. Article 17. It is titled as Abolition of Untouchability. It is a curse for our society. Untouchability is abolished. Its practice in any form is forbidden. The enforcement of any disability arising out of untouchability clause shall be an offence punishable in accordance with law. The position is further fortified by abolition of the Untouchability Act of 1955. Though the term untouchability has not been defined in either the Constitution or the Act of 1955, practice of untouchability in any form is strictly prohibited. Refusing admission to public institutions like schools, hospitals, restaurants, etc. on grounds of untouchability is a punishable crime. Article 18. Abolition of titles. No title, not being a military or academic distinction, shall be conferred by the state. No citizen of India shall accept any title from any foreign state. No person who is not a citizen of India shall, while he holds any office of profit or trust under the state, accept without the consent of the President any title from any foreign state. No person holding any office of profit or trust under the state shall, without the consent of the President, accept any present or emolument or an office of any kind from or under any foreign state. The British government had created an aristocratic class known as Rai Bahadur or Khan Bahadurs in India. These titles have been abolished. However, military and academic distinctions can be conferred on the citizens of India. The awards of Bharat Ratna, Padma Shri, Padma Vibhushan cannot be used by the recipient as the titles. They do not accordingly come within the constitutional prohibition as proposed by Article 18. The Supreme Court on 15 December 1995 upheld the validity of such awards. Before I finish, let us remind you this right to equality has been developed on the basis of the Dicey's concept of rule of law. The name of his book is Introduction to the Study of Law and Constitution, which says there is absolute supremacy or predominance of a regular law as opposed to the influence of arbitrary power, and no man is above law and every person is equal before law. But for enforcement of right to equality, actually, we need to have equal access to judicial machineries. And state government has provided for legal aid, but proper education, proper legal awareness are also the basic necessities so that every citizen, irrespective of their socio-economic status, can have an access to right to equality.